way, shape, or form. Number 3, there are other ways of proving where a person is other than using a highly prejudicial home confinement. They could have used phone records, which were quite available. They had a warrant. They executed a warrant. My home tore it apart and took many, many things, so there would have been no problem to get a warrant for the home line that was required for home confinement. And the home line, you have to be at home to use it. And so that would have been evidence of where I was at. And having an officer take the stand and say that I was on home confinement at the time is highly prejudicial. He talked about the conference call and the video interview, as well as the telephone calls from the regional jail. Once again, that was prejudicial in and of itself because they're testifying that I was in jail while making these phone calls. There wasn't the proper foundation or authentication required to have those entered into evidence. And the interviews were on the internet, but they were not available to download. YouTube, you go, you stream it, you watch it there. On the whodoc.info site, you play the file there. There's nothing that says on either of them that you are permitted to extract it, take a copy of it, and then use it for private purposes of any nature. And that's a seizure of a protected, what would you want to call it? I mean, it's personal property. On the one on YouTube, the gentleman maintains that as his own channel. It is his personal property to do with as he wants. Now, if the state would have contacted him, they may have been able to get a copy from him. Otherwise, you need a warrant to take someone's property, intellectual property. And the same with whodoc.info. You can listen to it there, you can stream it there, but you can't take it. And both were taken. And that's what my argument was with those, as well as the authentication and proper foundation to get them into evidence. As I showed in there that he had claimed, and this was Trooper Williams, he claimed that he had downloaded it on the 22nd, but the file itself was labeled as the 17th, so someone else had downloaded it, and he was claiming it was him, and he had no answer for that on the stand. And I think that he said that I approved jury instructions. I mean, I'm not sure which he's talking about. If he's talking about the charge to the jury or the instructions. I asked for many things to be changed in the instructions and got 0 of them changed. So, to say that I approved it would be a stretch by far. Even if just a few of the things would have been changed, I would have been happy. Even just defendant to my name would have been better than having defendant prejudicially scattered throughout. And I do not think that, as we define threat, I think that, the jury, being laymen, would have a problem in reading legalese contained within the code, and that the jury charge should have been written, or at least some other explanations given to let them know what it actually meant there, because I think a lot of them would have problems reading legalese. They're not trained in the law. I have problems reading it, and I read it all the time. A lot of these are rights protected by the Constitution, and these rights say they shall not be abridged, they shall not be infringed, and any infringement or abridgment of them is a violation of that contract. And I don't see anything else I need to say. I think that was it.
Okay. The first general heading is the described as insufficiency of the evidence. But specifically, no evidence terrorist threat was communicated to the victim. The statute doesn't seem to require that. If it merely needs to be made, there's no requirement that it be communicated to a victim. And from the phone conference, it's clear that there was a threat that was communicated. It was communicated to several different people. I have never sat down and counted up how many people were on the phone call or the phone conference, but there were several people on that phone conference listening to the phone conference. In fact, if no victim testified, again, the statute doesn't require it. In fact, several crimes, there's no what one would, I guess, characterize as a traditional victim. Driving offenses, all the driving under the influence, driving on a revoked license, those don't have traditional victims. A felon in possession of a firearm, there's no traditional victim. The victim is the state. There's a whole articles under the criminal code that deal with crimes against public policy, crimes against different things other than crimes against the victim. So the court doesn't believe that simply because the victim doesn't testify that is any infirmity in this case. Protected speech. It is black letter law that not all speech is protected. You cannot yell fire in a crowded theater. That's your traditional law school way of showing that not all speech is protected. A case in West Virginia, State versus Yoga, 233 West Virginia 439, and it discusses this statute. And actually, in that case, the challenge was void for vacancy. But one of the things that it talks about is permissible content-based restrictions on speech. And it cites a U.S. Supreme Court case that says that certain categories of speech are considered to fall outside the protections afforded by the First Amendment. And they go on to list some of them. Incite imminent lawless action, obscenity, defamation, fighting words, child pornography, true threats. And so those are just some of the ones that are recognized types of speech that can be subject to restriction and therefore fall outside the broad protection of the First Amendment. And the court would find that the statute is a lawful restriction on that group of speech. Again, deal with in personam jurisdiction and political jurisdiction. We've dealt with all those. No new allegations were made in the motion. And so the court would stand on its prior ruling. Also, the issue of error in the home confinement evidence. The court made the analysis that it needed to under Rule 404B, and it was admissible for an exception, and that was to establish that the phone call was made in Wood County and at a time when the defendant was in the home. Cautionary instructions given. Certainly a warrant, as the defendant is asserted here, could have been obtained. Whether it would show it or not, I don't know, because I don't know what a warrant would obtain if it was a phone call over the internet. But it also would not show who was on the phone or who was using the internet at the time. It It only showed that the internet or the phone was being used in that residence, but it wouldn't show who. And that's what the home confinement evidence did, was it established who was in the home at the time the phone call was made. In terms of the jail phone calls, the court has already ruled that it was admissible under the statute that dealt with phone calls from a regional jail. There was no new evidence or argument made. In terms of phone call from the internet, and the need for a warrant or no permission of the owner. Of course, this is fairly new, I think, area of the law. And so, there is a West Virginia case that deals with things that are put out to the public, and the fact that no warrant is needed in State versus Aldridge, which is 172 West Virginia 218, 304 Southeast 2nd 671, 1983 case by the West Virginia Supreme Court of Appeals. Talked about somebody who committed a crime, and I'm not sure what the crime was. I don't know that it matters. But anyway, he had an injured hand, and the court said that a person has no reasonable expectation of privacy in what he knowingly exposes to the public. And so, if you knowingly expose a conversation to the public on the internet, you have no expectation of privacy in that. And both of these work. We have a couple of federal cases, United States versus Merrick Gildo, 883, Fed Sup 2nd, 523 out of the Southern District of New York, 2012. It says when a social media user disseminates his postings and information to the public, they are not protected by the Fourth Amendment. Case out of New York, People versus Harris, 36 miscellaneous 3rd 613. This is 945. New York Supplement 2nd 505. 2012 case. The next slide is a Second Circuit case. That individuals do not have a reasonable expectation of privacy in internet postings or emails that have reached their recipients. Users would logically lack a legitimate expectation of privacy in materials intended for publication or public posting. And the United States Court of Appeals for the Sixth Circuit, 2001 case, 255 Fed 3rd, 325. Users would logically lack a legitimate expectation of privacy in the materials intended for publication or public posting. They would lose a legitimate expectation of privacy in an email that had already reached its recipient. It's analogous to a letter writer whose expectation of privacy ordinarily terminates upon delivery of the letter. So, the court believes that posting these, either the phone call and or this interview on the internet, that once that's done, there is no more expectation of privacy, which of course is the hallmark standard for Fourth Amendment analysis, and therefore no warrant would be required to copy them, extract them, however you want to say it. It doesn't matter because there's no expectation of privacy.